In this video, I'm going to take a look at the implied terms in the contract of employment. So in the employment contract, you're going to get or should get a written statement of terms of employment. So that written statement is going to contain express terms. In other words, terms that are expressly agreed between you and the employer, and they're going to be set out in writing. However, there's also going to be implied terms in a contract of employment in Ireland. And in this video, I'm going to take a look at how they can arise and what they are. So the background, as I say, is when a contract of employment is drawn up, it's impossible to provide for every eventuality in the work relationship between the employer and employee. And therefore there will be express terms, but there will also be implied terms. So firstly, we need to look at what conditions are necessary for implied terms to be implied into a contract. Firstly, one of the conditions or one of the circumstances may be custom and practice. If you are to rely, however, on custom and practice to incorporate an implied term into a contract, the custom should be reasonable, notorious, that is, well known and certain. This might arise, for example, where an employer pays an annual bonus for many years. So an employer pays an annual bonus for many years. It's arguable that there is an implied term of employment, implied term in the contract of employment, that a bonus will be paid. And you're going to be relying, if you're an employee, on custom and practice, implying that term in. The second set of circumstances where an implied term may arise is on the grounds of business efficacy. This basically means to make sense of it and to make it workable, that is, the contract. So this would occur where it is obvious and necessary. For example, the obligation for a lorry driver, or indeed any commercial driver, to have a driving license. So there's an implied term, even if it's not explicitly stated in the contract of employment, that if you drive for a living, then there's an implied term that you have a driving license. The third sort of condition or circumstances which might give rise to an implied term would be the officious bystander test. This occurs where something is so obvious that it goes without saying, and a third-party observer would agree that it was blatantly obvious. I don't have an example of this, but it is obvious, if you pardon the pun, when it does arise. So that is the officious bystander test. The fourth sort of set of circumstances which will give rise to a term being implied into a contract of employment is the conduct of the parties after the contract has been formed. So after the contract has been made, the employment has commenced, then it can arise that the course of conduct between the parties can give rise to an implied term being incorporated into the contract. Now, it would be necessary to show an intention by the parties to include it as a term, but nevertheless the conduct of the parties after the contract of employment has been entered into over a period of time may give rise to the perfectly reasonable inference or implication of a term of employment into the contract. And number 5, set of circumstances implied by statutes. For example, here, an example here would be if there was no notice period expressly stated in the contract, it's implied that the statutory notice period will apply. So the contract, by way of an express term, may be silent in terms of a notice period, but you can imply that the statute obviously is going to kick in and provide the notice period that's required. 6, terms implied by law. These will include the obligation on the employer's part to provide work, and on the employee's part to follow reasonable direction and show good faith and loyalty to the employer. These are implied terms. So good faith and loyalty, follow reasonable direction. So you may have a contract of employment that says you are, for example, a sales assistant. If, however, the requirements of the business change and your role or some other duties may be required of you in the normal course of business, and these duties are related to or similar to or related certainly to your job or business requirements, then it could be implied that you are obliged to follow reasonable direction and carry out the other duties, even though they may not be expressly related to sales. They may be not directly related to being a sales assistant. For example, keeping a sales area clean and tidy and doing a bit of cleaning and sweeping and so on and so forth. So you do need to follow reasonable direction. You do need to show good faith and loyalty to the employer, and the employer needs to provide work for you. The seventh bunch of circumstances that might give rise to a term being applied into the contract of employment would be those that derive from the provisions of the Constitution. Examples of this would be the right to join a trade union, the right to fair procedures in reaching decisions which affect the rights of the employee, and the right to earn a living. So the right to earn a living one there might come up in relation to restrictive covenant in a contract, whereby the employer may seek to restrict an employee who leaves from working in a particular industry or in a particular area or both for perhaps 12 months, 18 months or something like that. This clashes with the employee's right to earn a living. So generally, in relation to a restrictive covenant, the geographical area and the time period that is sought to be covered by the restrictive covenant must be reasonable. Why? Because the employee has a right to earn a living. Where does this right come from? It comes from the Constitution. So that is in a term that's implied into the contract of employment by the Constitution. Common implied terms then, 4 common ones would be: 1, the mutual obligation to maintain trust and confidence in each other. In other words, the employer is entitled to have trust and confidence in the employee, and vice versa. There's also a duty of loyalty. There may be a duty in relation to, or may be an implied term in relation to giving references. That will depend very, very much on the industry, but there may be an implied term in specific or particular industries that a reference will be provided, because without the reference, it may be in that particular industry virtually impossible to get a job. So, that doesn't arise all the time, and it will depend on the industry, and it is perfectly okay for an employer to have a contract or to have a policy of not giving references, but particularly or maybe only giving statements of employment. There's also an implied term that there will be a grievance procedure in the workplace. In other words, that whatever complaints or worries or issues an employee might have, that he or she has the obligation, or has the opportunity rather, to ventilate those issues in the workplace. Hope you find this useful. If you do, give it a thumbs up down below, and my contact details are on the screen. You may be interested in subscribing to my YouTube channel. If you are interested, just hit the subscribe button below, and as I say, give it a thumbs up. Thank you.